first off, just go back over what I was just saying there. Like the main point I'm looking at here is like you're effectively acknowledging a whole shitload of things that the court has done.
Right.
Like you're saying that. I know, it's not a straight up acknowledgement from your part, but it's close enough. It suggests that. So at page 2, bottom of page 2, you're saying that it suggests that even they did not perceive the proceedings to be so entirely vexatious or groundless. Hello?
Yeah.
Sorry,
Okay,
there
I'm
was just
hearing you.
noise there. Then you go on the next paragraph. While the Honourable Court upheld the findings of abuse of process. Again,
You're agreeing
you're
with them.
acknowledging that the court has upheld it. And then further down, you go on, I'm going to glance through this now. One paragraph here, costs are ultimately the discretion of the court, given the complexities involved, the genuine, even if ultimately legally unstatable concerns. You're effectively admitting that it was unstatable. The
Right.
bottom
Okay.
page 4. What else have I got there? You've a chance here to turn around and hit them really fucking hard. I think you need to take the gloves off here.
Right. Okay.
I think, here, two things I know there's a couple of things I know that are 100% true.
Right.
Even the court service data protection notice states that the court is a data controller.
Right. Okay.
Okay. Now, fundamentally, there is nothing, and I really want to stress this, there is nothing under Article 82 GDPR or anything in the GDPR that interferes with the person's right to compensation for non-compliance with the GDPR. Nothing.
Okay.
Okay? So straight up here, the point is, one, the court is a data controller, and you reference from its own from your own privacy statement, the court is a data controller.
Okay.
Nothing under GDPR limits or in any way serves to limit your right to compensation for breach of the GDPR.
Okay.
Okay? Straight up fact. Now,
Right.
as matters stand, and this goes right back to the fundamental points of appeal that we were talking about here.
Okay.
In the other recordings, necessity of processing dictates that the mere existence, and I'm going to really, really emphasize the mere existence of any alternative, equally effective means of processing that was available to the controller means their chosen means of processing is not necessary.
Okay.
As a consequence, the mere fact that the Court of Appeal could have redirected the case back to the High Court for hearing,
Right.
for where a full trial, where the facts could be spelt out, means that you are that their processing was unnecessary, and as a consequence, it is unlawful. The court's processing is unlawful under Article 6.1 GDPR because it will not have any legal basis under Article 6.1 to enable its processing.
Okay, and that's what
And
you'd be going into this.
hold on, I'm not finished.
Okay.
As a consequence, because the court is a data controller, unless the court can demonstrate why it is absolutely necessary to strike out the proceedings, and why it was necessary not to let it go back to the court, the High Court, for a full hearing, then the court's processing is unlawful and consequently in severe breach of the GDPR. As a consequence, if the court awards costs against you, you will have no choice but to seek to recover those costs from the court and the court service, Chief Justice, the President of the High Court, well, Chief Justice anyway, the Minister for Justice, and the Attorney General for failing to implement appropriate and effective measures to comply with the GDPR and to protect your fundamental rights and freedoms. Okay? Now, this is sort of language, and basically you're calling out, lads, you want to be absolute fuckfaces. Fine. You've disregarded GDPR left, right, and centre. What you have done, you were informed that you don't put this part in. You were informed that you were data controllers.
Yeah.
Right, you want to fuck around here. As data controllers, you're liable. Now,
Right.
that's that. I think you need to pull the fucking gloves off here. You need to, strongly disagree with what they've done here.
Okay.
And really rattle them. That when you go into the Supreme Court or the Court of Justice, you know where this is going. When we turn around and put our own proceedings before the courts for breach of, to give an example in your submissions here, at the very minimum, you had an Article 79 GDPR right to an effective judicial remedy, which was denied to you by the High Court and by the Court of Appeals.
Right.
Straight up. You need to call that one out straight up. You had an Article 79 GDPR right that was denied to you.
Okay.
The High Court, the processing by Cregan was not necessary. When he could have allowed it to go to trial rather than striking it out, where the issues could have been heard. As a consequence, Cregan's processing is unnecessary.
Right.
I think you need to really pull out the fucking gloves here and really hit them between the eyes. And when they see this, they have not perfected that order yet.
No.
And I think if this comes in, they will not perfect the order.
Right.
Or you're daring them to.
Right. Okay.
I think you need to just you need to just
Hammer
hit
this
them
home.
fucking hard on this.
Okay.
Like
Okay.
the problem I have with this here, it's too polite.
Okay. I'm going to send this on recording then.
I will. It's too polite. First thing is too polite, and I think you're acknowledging it could be conceived by the Court of Justice, Supreme Court. You're acknowledging the findings of the court and giving it credibility.
Credence. Right.
I think you need to rip it to fucking pieces.
Right. Okay.
And I think now, in the context of what I'm saying here about necessity of processing, you can make the other points that all the respondents didn't seek the strikeout. You can make the other points you're talking about here. These are all, relevant. But Jesus Christ, I think don't admit anything. That's my personal feeling.
Right, okay.
Walk in and hit the fuckers 3 separate punches right in the fucking snout.
Right.
And make them sit down and think, right, you want to act the shit, you're up there in your high horse on the bench. You're literally in your fucking ivory tower. But by Jesus Christ, the fact that you're in your ivory tower, you are a data controller, you are fully fucking liable, and
they know they're data controllers.
They do, because their own public statement on the privacy notice says that, and I would refer to that.
Right, okay.
Right,
okay. So, send that recording on.
But listen, come here.
Yeah.
Just for all of you, I have to stress, I am not a lawyer. I'm a fighter. Right. When I get after, I fight fucking hard when it comes to this.
And that is good. Yeah.
And
okay, that's all we need.
But you have to make your own decision in this. And for all I'm saying, it's the value this has. I could be howling at the fucking moon for all the value it has. Honestly.
No. I appreciate everything you're saying there.
Let me put it differently.
I appreciate it as well.
Let me put it a different way to you, right? As things stand at the moment, they're giving you the 2 fingers. They told you to fuck off.
Yeah.
They've screwed you over. They're taking your property off you. They're not listening to GDPR. Oh, the other thing I'd put in as well. This is also really important.
Right.
So again, the statement of claim that we've prepared for you. You have Articles 29. Is it 4, paragraph 6 and 10? I think it is, of the Constitution. Mm-hmm. Establish the supremacy of EU law.
Right.
Okay, the courts themselves have a constitutional duty to due process, which means that effectively what's happened here is they have, the courts have denied you your right to be your constitutional right to rely on the supremacy of EU law.
Right.
Now, what you're doing here is you're bringing it back to the Irish Constitution. There's not EU law. The Irish Constitution gives you the right to rely on the supremacy of EU law, and in particular on the Charter of Fundamental Rights, the European Convention of Human Rights, and the GDPR. I'd be putting all 3 in there.
Okay.
And purely on that alone, this has enormous public interest.
Okay.
And, and as a consequence, costs should not follow when such, significant public interest is knocking around. This is a constitutional problem here.
Right.
Now you're setting the grounds here for this to go to the Supreme Court if you want to, because you're basically saying they get the two fingers to the Constitution,
Right. Okay.
if that
Right.
makes sense, you know?
Yeah. 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 No problem.
But
Okay.
that's my high level. I've only
Okay.
glanced at it,
Well,
you know?
I'd say Pat will take that all on board and put it into a
Sure.
submission.
Look, to Pat, like, I'm not being critical in any shape or form. I just...
No. We want help on every angle, and right. And all we, but my thing is to fight with them. Pat is the same, and to fucking give them a bloody nose, right?
Exactly. I think at this stage, like, look, we're taking on the state here. We're taking on the judiciary. They're not playing nice. And
Right.
by fuck, if there is consequences for them doing this. The beauty of GDPR is that it surpasses all other stuff that's out there. They're data controllers. Unless they can produce why it was necessary for them to not send it back for hearing, then that's automatic non-compliance with the GDPR. End of story. And there's no amount of evidence or documentary evidence that they have right. So on that alone, right, we're looking at, and again, you can put it in if you don't put it in, right, but you can. But maybe there is value in mentioning this in the court. So Article 1, Paragraph 2. So if I list off all the contravention of GDPR that I believe I see from what's happened. There's contravention of Article 1, Paragraph 2 of the GDPR, which states that the regulation protects fundamental rights. Fundamental rights are going to be those under the Charter and under the European Convention on Human Rights. There's going to be a breach of the first and third principles of GDPR at minimum. First principle, processing has to be lawful. In other words, it has to comply with the Constitution.
Right.
It has to be fair. It has to comply with the Constitution. It has to be transparent. Okay, it's not clear how the court has come about that, so let's not go there. So, first breach of the GDPR, Article 518. Breach of the third principle of GDPR as well. Was the decision of the court and the processing of the court adequate? And in other words, adequate, did it adequately address the legal issues in relation to lawfulness of processing? Because you asked under Article 6.1 in your High Court stuff, you had a right to an effective judicial remedy. It's not adequate. Right. And the court, of its own motion, decided that, well, actually, you know what, you could have gone to the DPC. Well, that's not good enough. The fact that you have a right under GDPR to lodge a complaint with the DPC, I think it's Article 77. In no way does that actually, substitute your Article 79 GDPR right to an effective judicial remedy. They're two separate things.
The court had a duty.
So the processing was not adequate. Was it relevant? It disregarded its constitutional duties under Articles 29, 4, 6 and 10 about the supremacy of EU law. So it was not relevant.
Okay.
And it was not necessary because there was another thing they could do, which is to send the thing back for a full trial. So straight away, you're looking at a breach of the second principle. Now, on top of that then, Articles 5.2, the court must be in a position... Sorry, forget that. Move on. Article 24. Article 24 says that the court must implement appropriate, effective measures that effectively protect your rights and freedoms. Now, that's generic. It's rights and freedoms, not fundamental rights, it's rights and freedoms. That includes your constitutional rights, which includes your constitutional right to rely on the supremacy of EU law, constitutional right to due process. You're looking at your statutory right under Article 79 GDPR for an effective judicial remedy. They've disregarded that. You're looking at your rights under the Charter. Your fundamental right to a fair, an effective remedy and to a fair trial, Article 47. The right to protective personal data, Article 48 of the Charter. That goes with your Article 7. I can stay going. Now, so there's a breach of the third principle. Articles 24. They have not implemented. They cannot demonstrate how they implemented appropriate and effective measures. And the proof on this is going to sit inside in the Superior Court rules. Right. They don't, those rules do not have GDPR embedded and protection of GDPR embedded in things. And the court itself gave the two fingers to disregarding GDPR.
Okay.
Right. Same with Article 25, 35.
But then that leaves them in breach of the European.
Of course it does.
Yeah.
He's in breach in wholesale disregard of GDPR. But like fundamentally, the first parts I talked about on the first part of the recording, they're the most important because you don't want to get too complicated into the other shit. But what you can do is there's no reason why you couldn't simply call out, the processing by the Court of Appeals, and I guess the High Court as well, is in contravention of Article 1.2 of the GDPR, Article 5.1a, 5.1c, Articles 6.1, 24, 25, and 35 GDPR.
Okay. And that'll put the cat among the pigeons when you send that back.
It will, because when you say they're controllers, that if they award costs against you, you have no choice but to recover because they've disregarded GDPR in their judgment.
In Article 79. Yeah, okay.
Right. Now, you see, this is the problem I have, and it came back in one of the messages from, I think, Holland or someone else like that, or the judge said, basically, there's the process the court has today that allows people to appeal stuff and so on and so forth. And that's supposed to give people, the checks and balances to protect things. However, GDPR gives an entirely new parallel mechanism where you can hold an individual judge fully liable as a data controller for all your losses.
Okay.
And that's a scary, scary thing. Now, there's nothing within the GDPR that limits that. Nothing.
Right, okay.
Right.
So, okay. Send on that recording to me and we'll have a view of it again, a review of the submission.
Grand. Okay, cheers.
Thanks, Colin. Thanks.
No problems. Bye.